Yes, so election just done in Jamaica. It was a landslide for the Jamaica Labour Party, which is the capitalist party. And so we're just going to continue the series on the Jamaican Constitution. And we're at chapter 6 now, chapter VI, executive powers. So chapter 6 start executive authority of Jamaica. First point, the executive authority of Jamaica is vested in Her Majesty, and that is Queen Elizabeth II. Subject to the provisions of this constitution, the executive authority of Jamaica may be exercised on behalf of Her Majesty by the Governor General, either directly or through officers subordinate to him. Nothing in this section shall prevent Parliament from conferring function on person or authorities other than the Governor General. And chapter 6, section 69 says cabinet. There shall be a cabinet of Jamaica which shall consist of Prime Minister and such members, such ministers, other. Yeah, so the cabinet shall consist of Prime Minister and such number of other ministers not being less than 11. Okay, so the cabinet must have at least 11 members. I didn't know that. Selected from among ministers appointed in accordance with the provisions of section 70 of this constitution, as the Prime Minister may from time to time consider appropriate. The cabinet shall be the principal instrument of policy and shall be charged with the general direction of the control of government of Jamaica and shall be collectively responsible therefore to Parliament, not less than 2 or no more than 4 ministers selected pursuant to subsection 1 shall be persons who are in the Senate. So you have to have 2 senators being a part of the cabinet, at least 2, however, no more than 4. So you can have 2 members, 3 members, or 4 members of the Senate being a part of the cabinet. Good information. I did not know that before this. I thought that senators could not be cabinet ministers. However, I think there are a few senators that are actually part of the cabinet, as the Constitution states here. Appointment of ministers. Wherever the Governor General has occasion to appoint a Prime Minister, he acts in his discretion, shall appoint the member of the House of Representatives who, in his judgment, is best able to command the confidence of the majority of the members of that House, acting in accordance with the advice of the Prime Minister. Appointment from among members of the 2 houses, such as members of the Prime Minister's advice. So that's how the Governor General appoints ministers. Basically, the Prime Minister recommends who he sees fit to be in his cabinet. This usually comes from his side of the aisle, his party, right? So they usually typically form the government because most of Jamaica's government are formed along party lines, which is like most other countries. If occasion arises to make an appointment while Parliament is dissolved, a person who was a member of the House of Representatives immediately before dissolution may be appointed Prime Minister, and a person who was a member of either House immediately before the dissolution may, subject to provision section 2 of this section, be appointed as any other member of the House if in case such person were still a member of the House in question, but any person so appointed shall vacate the office beginning of the next session of the House if he is not a member thereof. So in dissolution of Parliament for elections, person still may be appointed as minister, and it's saying if something happens and this person hasn't won their electoral seat or has been removed from Senate, they shall vacate that cabinet ministerial post. And I think everyone would have been changed up as well. based on the results of the election, like the one just concluded. Tenure of Office of Minister. The office of the Prime Minister shall become vacant if he resigns office, if he ceases to be a member of the House of Representatives, otherwise than the dissolution of Parliament. So basically, if the Prime Minister loses electoral seat, he cannot continue as Prime Minister even if the government wins. For example, if Andrew Holness has lost his seat, even with this landslide victory, he could not continue to be the Prime Minister of the country not having a seat in the House of Representatives. That's what this is basically saying. If the Constitution is required to cease to exercise any of the function as member of House of Representatives, or when, after any dissolution of Parliament, the Prime Minister is informed by the Governor General, acting in his discretion, that the Governor General is about to reappoint him as Prime Minister or appoint another person as Prime Minister. Also, if the Governor General revokes his appointment in accordance with the provisions of subsection 2, if the House of Representatives, by resolution, which has received affirmative vote of majority of all the members thereof, resolve that the appointment of the Prime Minister are to be revoked, that the Governor General shall subject to the provisions of this section by the instrument of broad seal. So, how I see this applying is that, let's say, for example, Andrew Holness was the Prime Minister, right? And within the internal runnings of his party, let's say Christopher Tufton was challenging him for the head of the party, being the party president. If he's not the victor, then Mr. Tufton would have assumed the prime ministerial role, because the members on his side of the House, which is the majority, would have voted in favor of Chris Tufton to overturn Mr. Holness's right as Prime Minister. Or same could be said about Portia Simpson versus Peter Phillips, and it would have changed the whole dynamic here in the House. Upon appointment or reappointment of any person in the office of Prime Minister, if the appointment to his office is revoked by the Governor General in accordance with the advice of the Prime Minister, instrument under the broad seal. So those are the ways basically the persons can be removed from their cabinet position and the office of the Prime Minister with the Prime Minister's advice, with the Governor General acting upon that, or if there's a majority revokement of the Prime Minister's duties by the House, the mass of the House. So it doesn't have to be in his party either. If members of the opposition form a coalition and the coalition makes the majority, and the majority of the coalition doesn't see, say for example, Andrew Holness being the Prime Minister, he would have to cease being the Prime Minister. So like the last election, they won by 1 seat. If, for example, someone had fallen out of favor with his party and crossed the aisle, the opposition would have the majority, and then the Prime Minister might have come from the opposition, or they might have chosen someone else that would represent both sides of the House, depending on how you look at it and the constitutionality of that, basically. Next point says, performance of Prime Minister's function in certain events. When the Prime Minister is unable, by reason of illness or absence from Jamaica, to perform the functions of his office, the Governor General may, by instrument of broad seal, authorize any other member who is a member of the House of Representatives to perform said functions conferred on the Prime Minister by this Constitution. The Governor General may, by instrument under broad seal, revoke any authority given under this section as well. The power conferred on the Governor General by this section shall be exercised by him acting in his discretion, if in his opinion is impractical to obtain the advice of the Prime Minister owing to the Prime Minister's illness or absence, and in any other case shall be exercised by the Governor General in accordance with the advice of the Prime Minister. Point 73 is temporary ministers. Whenever a minister other than the Prime Minister is unable for a reason of illness or absence from Jamaica, yeah, so basically the same would apply for the absence of ministers. So if the Prime Minister is absent, Governor General might appoint another minister to fill that role. Or if another governing minister is also absent, someone else from that side of the house of the ruling party would substitute temporarily for him if he's ill or absent on international duties. Subject to the provisions of Section 71, the Constitution of a temporary minister shall hold office until he is notified by the Governor General by instrument of authority that the minister, on account of whose inability to perform these functions, was appointed again to perform these functions until the minister has vacated his office. So, without the Governor General reappointing, notifying that temporary minister, he would be the minister until such official vacation. Next one says the power conferred on the Governor General by this section shall be exercised by him in accordance with the advice of the Prime Minister. So the Governor General can't just get up and appoint anybody. You have to ask the Prime Minister's permission. The Prime Minister and every other minister shall, before entering upon the duties of his office, make before the Governor General the oath of allegiance appropriate and the appropriate oath for the due execution of his office in the form set out in the first schedule of this Constitution. Presiding in the Cabinet, the Prime Minister attend and preside at all meetings of Cabinet, and in his absence, the Governor General to be informed concerning the matters of government, right? The Prime Minister shall keep the Governor General fully informed concerning the general conduct of the government of Jamaica, and shall furnish the Governor General with such information as he requests with respect to any particular matter relating to the government of Jamaica. Assignment of responsibilities to ministers. Subject to the provisions of this Constitution, the Governor General, acting in accordance with advice of the Prime Minister, by direction in writing, change any minister who is a member of the House of Representatives, except for those inconsistent with the ministerial functions under Section 67, 115, 116, and 118 of the Constitution, who is a member of Senate with responsibility for any subject or department of government. Nothing in this section shall empower the Governor General to confer any minister or authority to exercise any power to discharge any duty that is conferred or imposed by this Constitution. Yeah. The next point is parliamentary secretaries. The Governor General would advise the Prime Minister, using the broad scale, might appoint parliamentary secretaries from among members of the two houses to assist ministers in the discharge of their functions. if the occasion arises, make an appointment to the office of parliamentary secretary while the parliament is dissolved. The person who is member of either house shall be appointed as if he were still a member of that house, but any person so appointed shall vacate the office at the beginning of the next section. Provisions of subsection 4 of section 7 and section 74 of this constitution apply to parliamentary secretaries as they apply to ministers. And the next point is that of Attorney General, which is point 79. There shall be an Attorney General who shall be the principal legal advisor to the government of Jamaica. Power to appoint a person to hold or act in this office of Attorney General and to remove from that office a person holding or acting in it shall subject to section 4 of this section be exercised by the Governor General acting in accordance with the advice of the Prime Minister. Any person appointed to hold or act in such office of Attorney General pursuant to subsection 2 of this section shall not except in accordance with the provision of section 70 of this constitution be appointed a minister. So the Attorney General shouldn't be appointed a government minister. That's what this part is saying. Until an appointment of a person to hold or act in the office of Attorney General is made under the provisions of section 2. It shall be a public office and a person shall not be qualified to hold or act in office unless he or she is qualified for appointment as a judge of the Supreme Court. So you have to be very qualified to act as Attorney General. On the occasion of the first appointment of a person to hold or act in the office of Attorney General under the provisions of section 2, the office of Attorney General as a public official be deemed to have been abolished. Point 80, leader of the opposition. There shall be a leader of the opposition who shall be appointed by the Governor General by instrument under the broad seal. Whenever the Governor General has occasion to appoint the leader of opposition, he shall, in his discretion, appoint the member of the House of Representatives whom his judgment is best able to command the support of those members who do not support the government. Right? That's why the opposition, because they don't support the government side of parliament. So they can be a coalition or they could be a single opposition. Most of the majority of the time, the single opposition is the people, either the People's National Party or the Jamaica Labour Party. What I want to know, right? If there's a third party and the third party doesn't fully support the government, however they support a lot of government policies, is that really a coalition opposition or would that just strain the government? It's strange to look into one. Right, so the ministers independently that oppose the government are the opposition. Let's say that. So, the leader of opposition shall officially become vacant if he resigns, dissolution of parliament, ceases to be a member of the House of Representatives, if his appointment is revoked by subsection 5 of this section, if the occasion arises to appointment made after the dissolution of parliament, or if in the judgment of the Governor General, the leader opposition does not command the support of the majority of those in the opposition. So it's basically the same scenario that I went through for the Prime Minister's appointment, but just using among opposition members, basically, if there's a internal election, or if he's clearly unfavored or corruption or something to that effect. So it says on point 81, it says certain vacancies in the office of the leader of opposition. During any period which there is a vacancy in the office of the leader of opposition by reason of fact, then no person is both qualified in accordance to this constitution for and willing to accept appointment to that office. The Governor General shall act in accordance with the advice of the Prime Minister on any matter in aspect in which is provided on this constitution either. The Governor General shall act in advice of the leader of opposition, or the Governor General shall act on the recommendation of the Prime Minister after consultation with the leader of opposition. So even though it's an affair having to do with the leader of the opposition, the Prime Minister says that they can be consulted. I see this as a conflict of interest. However, there must be some merit to having the Prime Minister's input in that, because the Prime Minister could favor someone, as I said before, in a coalition opposition that has a view closer to his party base, and that would in turn favor him for upcoming elections, his policies per se. So I see that as a conflict of interest. Anyway, so that's the constitution we abide by for now. So we have to just work with it. So it says in point 82, Privy Council. There shall be in and for Jamaica a Privy Council. It shall consist of 6 members appointed by the Governor General after consultation with the Prime Minister by instrument under broad seal. At least 2 members of the Privy Council shall be persons who hold or have held public office. The Privy Council shall have such powers and duties as may be conferred or imposed upon by or under this Constitution or any law. Point 83, tenure of office of members of Privy Council. The seat of a member of the Privy Council shall become vacant at the expiration of 3 years from the date of his appointment or such earlier time as may be specified in the instrument by which he was appointed. If he resigns his seat, or if his appointment is revoked by the Governor General acting after consultation with the Prime Minister. If any person is appointed to be a provisional member of the Privy Council under Section 85 of the Constitution, the tenure of his seat and provisional member is immediately followed by his substantive appointment as a member under section for a period of 3 years. Incapacity of a member of Privy Council. The Governor General, acting after a consultation with the Prime Minister, may, using the broad seal, declare that a member of the Privy Council is, by reason of absence or infirmity of body or mind, temporarily unable to discharge his functions as a member of the Privy Council, and thereupon that member shall not take part in the proceedings of the council until he declared in like manner to be able again to discharge those functions. And next point says provisional appointments to Privy Council. Whenever a member of the Privy Council under the section that preceded this one of the Constitution has been declared temporarily unable, the Governor General, under the Prime Minister's advice, shall appoint a person to be a provisional member, subject to the provisions in sections 84 and 83 Senior members of Privy Council, the Governor General shall appoint members of the Privy Council to be senior members. If any question in the votes of the members of the Privy Council are equally divided, the senior member shall have and exercise a casting vote in addition to his original vote. But, alright, okay, what I'm saying, the Governor General has to appoint senior Privy Council members, right? So is it that these senior Privy Council members are appointed at odd numbers unevenly? Because if there's equal amount of Privy Council members and they vote basically whichever way, if it's party line or they have the same vote and this vote is split down the middle, so it would only increase the number of votes, but it wouldn't change the results, basically, because if they get an additional vote and it's for them, it's one member. Okay, one member. Got it. The senior member shall preside over any meeting of the Privy Council which the Governor General is not present. So the senior member is like Speaker of the House of Privy Council or whatever. If at any meeting the Privy Council senior member is absent, the member present shall elect one of the members, exercise the powers and perform the duties of senior members at that meeting. Attendance of Governor General. Governor General shall, so far as practicable, attend and preside at all meetings of Privy Council. Summoning of Privy Council and procedure. The Privy Council shall not be summoned except by authority of Governor General acting in his discretion. If during any meeting of Privy Council, the Governor General or member presiding observe upon objections in that behalf shall be taken by any member present, that there are present less than 3 members besides the Governor General or a member presiding, shall thereupon adjourn the meeting. Subject to provisions of this Constitution, the Privy Council may regulate its own procedures. Validity of proceedings of Privy Council. The Privy Council shall not be disqualified for the transaction of business by reason only if any vacancy among its members includes any vacancy not filled when first constituted or is reconstituted at any time. And any proceedings therein shall be valid, notwithstanding that some persons who was not entitled so to do took part therein. Point 90. Prerogative of mercy. The Governor General may, in Her Majesty's name and on Her Majesty's behalf, grant any person convicted of any offense against the law of Jamaica a pardon, either free or subject to the lawful conditions. Granted to any person to respect either indefinite or a specified period for the execution of any punishment imposed on that person for such an offense. Substitute a less severe form of punishment for that imposed on any person for such an offense. He may also remit the whole or part of any punishment imposed on any person such that the offense or penalty or forfeiture otherwise due to the Crown on account of such offense. The exercise of the powers conferred on him in this section of the Governor General shall act on the recommendations of the Privy Council. Point 91. Pardon in capital cases. Where a person has been sentenced to death for an offense against the law of Jamaica, the Governor General shall cause a written report of that case from the trial judge, together with such other information derived from the record of the case, or elsewhere as the Governor General may require to be forwarded to the Privy Council, and also a notice to be delivered to the person sentenced, specifying the date. Being in the case of subparagraph 2 and 3, a date not less than 18 months. So this goes back to the first part of the Constitution where we're talking about the rights of the citizens. So it's talking about the duration. You can't have them for too long. And we went through that in the part that talks about the rights and freedoms of a citizen. So it says, shall commence any application or consultation with any entity outside of Jamaica other than Her Majesty in Council in relation to the offense for which the person has been sentenced to it. Shall conclude any applications to or consultation with any entity outside of Jamaica. May submit to the Governor General a consultation by the Privy Council representation relating to the case in accordance with such procedure and shall set out in notice, so that the Privy Council may make recommendation to the Governor General in accordance with Section 90 of this Constitution. Representation submitted under this section may include reports issued by the date specified under subparagraph of subsection by an entity referred to in that subparagraph, which is paragraph 1B and earlier in the Constitution that deals with the rights of a citizen. Nothing in this section 13 shall be construed as requiring the Governor General or Privy Council to exercise the powers conferred in section 90. The report issued by the entity submitted by the person sentenced before the date specified under the section. The Governor General, in giving, it's correct. Like the Governor General and the Privy Council, they pardon people on criminal offenses and even offenses of capital punishment. However, they cannot seek counsel from persons outside of the jurisdiction of Jamaica. They can seek counsel from persons from American legal system or whoever else. However, they may seek counsel from the courts in England, the high courts in England, which is Her Majesty's Court. So, also basically a colony of Britain right now. So, next section goes on to Cabinet Secretary or Secretary to Cabinet. There shall be a Secretary to Cabinet who shall be appointed by the Governor General acting on the Prime Minister's recommendation from the list of officers submitted by the Public Service Commission. The Secretary to Cabinet shall have charge of the Cabinet Office and shall be responsible in accordance with instructions as may be given to him by the Prime Minister for arrangement the business for keeping the minutes and Cabinet, the meetings of the Cabinet, and for the conveying of the decisions of the Cabinet to the appropriate personal authorities, and shall receive other functions as the Prime Minister may from time to time direct. So the Secretary takes the minutes, and if any governmental ministry or any organization should be notified, they are responsible for relaying the information. And the Prime Minister also may bestow other duties upon the Cabinet Secretary. Permanent secretaries, when any minister is charged with responsibility for a subject or department of government shall be he shall exercise general direction and control over the work relating to that subject and over that department, and subject as aforesaid and to such direction and control of the aforesaid work and the department shall under supervision of parliamentary secretary appoint in accordance with the provisions of section 126 of this Constitution. A person may be a permanent secretary in respect of more than one department of government. The Office of Financial Secretary hereby constitute and for the purposes of this section shall be deemed a permanent secretary. Establishment of the Office of the Function of Director of Public Prosecution, DPP, we all know it as DPP, which the current DPP is Paula Llewellyn. There shall be a Director of Public Prosecutions who shall be a public officer. The person shall not be qualified to hold or act in the office of the Director of Public Prosecution unless he is qualified for appointment of Judge of the Supreme Court. The Director of Public Prosecution shall have the power in any case in which he considered it desirable to do so. So this is the top judge in the country, basically. The public prosecutor. To institute and undertake criminal proceedings against any person before any court other than a court martial in respect of any offense against the law of Jamaica. To take over and continue any such criminal proceedings that may have been instituted by any other person or authority. To discontinue at any stage before judgment is delivered such criminal proceedings instituted or undertaken by himself or any other person or authority. The power of the DPP under Section 3 of this section shall be exercised by him in person through any other person acting under accordance of his general or special instructions. The powers conferred on the DPP by paragraphs B and C of this section shall be vested on him to the exclusion of any other person or authority, provided that where any other person or authority has instituted a criminal proceeding, nothing in this section shall prevent the withdrawal of those proceedings by or at the instance of the person or authority and with the leave of court. The exercise of power conferred upon him in this section, the DPP shall not be subject to the direction or control of any other person or authority. For the purposes of this section, any appeal from any determination in any legal proceedings before any court or any case stated or question of law to serve for the purposes of any such proceeding to any other court in Jamaica or judicial committee of Her Majesty's Privy Council shall be deemed to be a part of those proceedings. Point 95, remuneration of Director of Public Prosecutions. The DPP is subject to receive such emoluments and be subjected to such other terms and conditions of service from time to time, may be prescribed by or under law, provided that the emoluments and the terms and conditions of the service of DPP, other than the allowance that they are not taken into his account in computing pensions, shall not be altered to his disadvantage during his continuance of office. The salary for the time being payable to the DPP under the Constitution shall be charged on and paid out of the consolidated fund. Point 96. Tenure of the Director of Public Prosecutions and acting DPP. Subject to the provisions of Section 4 and 7 of this section, the Director of Public Prosecution shall hold office until he attained the age of 60 years. So the retirement point is 60. Decent career. Provided that he may be at any time resign his office. They always free to resign. The Governor General, acting on the recommendation of the Prime Minister after consultation with the opposition, may permit a DPP who attained the age of 60 years to continue until he has attained a later age not exceeding 65 years. Before the Director of Public Prosecutions has attained the age of 60 years, this has to be agreed between them. Nothing done by the DPP shall be invalid by reason only that he has attained the age which is required by the subsection to vacate his office. If the Director of Public Prosecution is vacant or the holder of that office for any other reason is unable to perform his duties, a person qualified for that appointment to that office shall be appointed to act therein. And any persons, so yes, the removal of the Director of Public Prosecution basically happen if the Governor General don't deem her fit, and they refer to the tribunal on which she was appointed to review it. If there's an inability to perform or for misconduct, basically. So that's why you can remove the DPP. The Prime Minister represents to the Governor General the question of removal of the DPP for inability, for misbehavior. Then the Governor General, acting in accordance with the advice of the Prime Minister, shall appoint a tribunal which consists of a chairman, not less than 2 other members from among persons who have or held office of judge of court, having an unlimited jurisdiction in civil criminal matters in some part of the Commonwealth. The tribunal shall inquire into these matters and report on the fact thereof to the Governor General, and the Governor General and recommend whether the DPP ought to be removed for inability or for misbehavior. The provisions of the Commissions of Inquiry law as in force immediately before appointment day shall subject to the provisions of this section and the third schedule of the Constitution apply as nearly as may be in relation to the tribunal appointed under section 6 of this section, as the context may require. To the member thereof as they may in relation to the commission or commissioner appointed under law, and for that purpose shall have the effect as effective as they form part of this Constitution. If the question of the removal of the DPP from the office had been referred to the tribunal under section 6, then the suspension may anytime be revoked by the Governor General acting in accordance of the Prime Minister, and shall in any case cease to have effect on the tribunal recommendations. So the tribunal would be appointed to remove the Governor General, but if the Prime Minister overrules the tribunal, then the DPP would be reinstated. And this basically ends up chapter 6. Next time we'll go to chapter 7, which is the judiciary. So hope you're more aware of the laws of the country, rights, responsibility, the role of our government officials. So until next time, peace.